Welcome back. Well, yes, those two gentlemen, Mr. Kehinde Eleja, Senior Advocate of Nigeria, as well as Comrade Emmanuel Abioye, who is the Deputy President, Judiciary Staff Union of Nigeria, Judicial, both join us this morning to weigh in on this subject matter. Gentlemen, good morning, and thank you for joining us on the program today.
Good morning. Thank you.
Good morning. It's my pleasure to be here.
All right, let's start with you, Mr. Eleja. Now, what a year it was actually for the judiciary, but I know that there will always be perspectives for that matter. So for you, what kind of year was it for the judiciary?
Well, thank you. Yeah, 2021 for me was a very challenging year for the Nigerian judiciary. The COVID-19 pandemic, which spilled to year 2021, undoubtedly affected the operations of the court and did not allow the court to perform at its optimal level. Additionally, the judicial strike embarked upon by the Judiciary Staff Workers Union of Nigeria, which lasted about 2 months, did not also help a matter. With these two factors, the judiciary couldn't perform optimally, and of course, it created a kind of a vacuum. Though this is not to say that the judiciary did not fare well, as they had been related in the course of the background information there. So many landmark judgments were delivered by the courts, and of course, the courts were able to discredit themselves well. Notwithstanding the challenge.
So what then do we make of that Supreme Court position that, between the Attorney General of Lagos and Attorney General of the Federation, that the courts could hold virtual seating when it had to do with COVID? Didn't that have some sort of impact? Because you say that impacted negatively COVID on the judiciary.
Thank you. You discovered that decision did not come in good time. And even when it came, many of the courts in Nigeria were not prepared to catch up with the challenges. You appreciate that the facilities will have to be put in place, even in places where you have network. In several places in this country, is either there is an outright network or you had network challenge. So it took time before the courts could adjust to this novel situation. And even at that, there were arguments as to whether the Supreme Court actually made that pronouncement or whether it was a mere obiter. Some courts were skeptical. They wanted to exercise a caution so that their proceedings are not pronounced a nullity at the end of the day.
So could you tell us, what is the current situation regarding that matter now? Have courts adjusted? Do they plan to adjust? Because who knows? We could have another scenario like this in the future.
Well, the good thing about it is that most of the courts have responded. For example, in the new Court of Appeal rules, there is now express provision for virtual sitting of the courts. Many state high courts have also moved in that direction, so that it is beyond argument now that the courts can sit virtually. And even many of the courts have responded to the situation. The Supreme Court, of course, the National Industrial Court, even the Federal High Court. The challenges we are having mainly is with the state, some state courts, and it's understandable, probably because of the issue of lack of independence, and they have in terms of financial autonomy. I think this is also a serious factor that needs to be addressed if the option of virtual sitting will be optimized.
Well, just before we talk to the Judicial Deputy President here, you said that the Judicial strike was significant. Could it have been avoided?
Well, I think it would have been avoided because it was a needless situation that was created by the executive arms in the various states. You agree with me that for quite some time, the federal judiciary, the courts, directly under the federal government, had been enjoying some measure of autonomy in terms of their finances. But most states, notwithstanding the express provisions of Section 1213 of the Constitution, which says that their money should be charged directly and be made available to them on the consolidation account, most state courts failed to, most state chief executives failed to give effect to the provisions of the Constitution. And of course, the federal government, through the president, went a step further by enacting Executive Order 10, which was intended to remedy the situation. Unfortunately, this did not achieve the desired impact. So it took the strike of the Judicial to kickstart the process for some of the states to start looking inward, and some of them now have passed their judicial autonomy law. So it was the strike of the Judicial. Of course, one cannot say it was baseless. Of course, there were justifications for it. But in a decent situation, it was avoidable if the chief executives of the state, who are the sworn to uphold the provisions of the Constitution, had kept to their oath of office and allowed the state judiciaries to enjoy their independence.
Mr. Leja, you spoke to the difference between the judiciary at the federal level and at the states. We'll come to that subsequently. But Comrade Abioye, in terms of your assessment of the performance or activities of the judiciary in the year 2021, from the judiciary staff's perspective, what would be your take?
Well, thank you very much. For us in the judiciary, of course, is one house. And I can say that not because I work there, we perform excellently well. So, I mean, when it comes to performance, of course, it's better to be rated by people who are outside the, institution. But definitely, like the Learning Six said, I mean, judiciary did not perform badly, save for the COVID-19 pandemic and crisis that we all witnessed in the country. So judiciary performed fairly well.
Well, if the judiciary performed fairly well, I'm wondering how come Justin had to go on strike at some point.
Yes, you see, the truth of the matter is when you're talking about the activities of the judiciary itself, I mean, we perform optimally to the best of our ability. So the crux of the bane of our problems is the lack of financial independence, which, of course, it is already in the public domain. So we did our best possible. And one of the things that we did, which can be adjudged as a landmark step we took last year, was the strike. Although it is avoidable, like the Learning Six said, but notwithstanding, I mean, we had to take the bull by its horn by going on strike. It's avoidable. So for us to make a statement, we for the first time, I mean, we made that statement that it cannot continue to be like that. We cannot continue to go cap in hand to the executive arm of government to ask for what belongs to us. So, I mean, when it comes to the activities of the judiciary, that was the first time ever, although unfortunately it affected so many people. We were not happy going on strike, so it affected us as well. So, but, I mean, for the first time, last year was the time we took the bull by its horn. Going on that strike, it was very necessary for us to make that statement so that it will send the signal to the appropriate quarters that, look, it cannot continue to be business as usual.
So how far with that particular issue that took Justin on strike? Has that issue been resolved?
No, not at all. I mean, not at all. Like Leonard Six said, of course, we did all we could to make sure that we achieve the financial independence, not even as at last year. This struggle has started a long time ago. And you may know that we went to court to institute action against all the state governors and the attorney generals. So, but however, unfortunately, I mean, the judgment, of course, of competent jurisdiction that was delivered on January 13, 2014 was not obeyed. So, I mean, it's unfortunate that up to now, that judgment had not been appealed against, and yet it was never implemented. There was no compliance to that judgment. And, I mean, further to that, we see that, okay, what do we do next? The best thing for us to do is to go on strike and to make that statement. So far, so good. Nothing much has been achieved. And you recall that there was an agreement, MOA, that was signed between the Governors Forum and our union. And that's to the extent that by the time we suspended the strike, that they were going to take necessary action of promulgating the fund management law at the state level. So up to now, we could only say that maybe like 3 states or so claim to have promulgated that law in their state. But yet, what ought to have followed up, which is the setting up of the fund management team, so that one has not been achieved up to now. So nothing has been achieved so far. So good.
So
Yes.
it then goes to, well, necessitates asking again, how would you say that judiciary performed fairly well when the enablement, which is the financial autonomy that you talked about, has not really been achieved?
We see, the truth of the matter is, it is not within, we are not the one to determine. We can only say what we have capacity or power to do, which if I say we have not performed well, I mean, I'm not being honest and I'm not being fair to ourselves, to the institution itself. So we perform to the extent of the ability that we have,
But it's not about being fair, really. It's just about stating what it is.
Yes, we
That's
perform
all.
well. So when you are talking about, for instance, we can't take responsibility for somebody else's action. So I can't take, judiciary cannot take responsibility for the non-performance of a particular arm of government. We're not the one to give ourselves money, for instance. So the performance in terms of activities of the institution itself, fairly well. But when it comes to, I think, in my own opinion, the best question, that question particularly, ought to be asked to be thrown to the executive arm of government.
Okay.
Yes.
Well, one of the issues that the SAN raised earlier is that of technology, which Chamberlain asked him. How open are judiciary staff to the inclusion of technology or use of technology in the activities of the judiciary? Are you, by any chance, threatened that there could be job losses?
No, not at all. We're not. The world itself is going digital now. So, obviously, for instance, we have taken that step a long time ago, especially in Lagos State. So the issue of judiciary information system, arguably started from Lagos State, for instance. So we are not threatened by any way that the judiciary is going digital in that way, because it makes the job easier. It makes people to have access to justice the more. So, you can't, for instance, necessarily compare people who are not within the jurisdiction to physically be present before you can now make decision in the court. So it's okay for us. We're not threatened by it at all.
All right, let me take this to Mr. Ledger. Do you subscribe to the school of thought saying that the judiciary may not or cannot do more than they're doing now without addressing the question of financial autonomy?
I agree perfectly with you, because when you talk in terms of performance, it has to be in relative terms. What are the facilities that are made available? You need to go to some of the states and see the appalling state of infrastructures. You see dilapidated courtrooms. Judges are not properly, they are not well treated as they ought to be treated. In many instances, judges are appointed without official accommodation. And even some support staff of judiciary who require to be trained from time to time in tune with modern trends are not trained, basically because in most of the states, the reality is that the chief judges, they go cap in hand to appeal to the executive, to the governors for funds to be allocated. And when such funds are allocated, they are so bigger that they are hardly able to achieve any meaningful result. So a major prerequisite for optimal performance of judiciary, therefore, will be to have full autonomy for the state, the judiciaries. It is not even sufficient that we have laws in place, this autonomy law and the rest of it. What is expected is to give them full autonomy, make sure that the money meant for them, the respective appropriation bills, are allocated to them. Let them have full control over these resources. They know what is of utmost importance to them. For example, we are talking about the issue of technology now. In the time past, in some states, attempts were made to digitize the courts and introduce electronic recording. But what happened eventually was that very irrelevant, outdated equipment, technology were brought in, which turned out to be useless to the courts. Whereas if the state enjoy full, the state judiciaries enjoy full autonomy, of course they will be able to determine what their need is, and they will be held accountable in case they fail to meet the expectations of the society from them. So I think you are right.
So how is the question of judicial autonomy, financial autonomy going to address concerns that was raised last time about forum shopping, and then you have people complain about quality of judgments that they see? So how is that going to have direct impact on these kind of issues?
You see, we are talking of multivarious challenges confronting the judiciary. Part of it has to do with issue of appointment of judges. If you look at it, you discover the current situation appears not too good enough. In many instances, you do not even know that the process for appointment of judges had been kick-started. All you realize is to read on the pages of newspapers or in the electronic media that so person had been appointed. So one would prefer a situation whereby the procedure will be made more transparent, just like it is done for aspirants for the rank of Senior Advocate of Nigeria. Let the names of prospective judges be advertised. People should be invited to make comments on their suitability in terms of their character, integrity, and in terms of competence. And I believe if that is done, of course, it's going to be a different ballgame altogether. Even though this is not directly related to the issue of autonomy at national level. But at the state level, it impacts on it. Because here is a state in which the governor controls the resources that will go to the judiciary. And of course, some of these governors see judicial appointments as political patronage to their supporters, to their sympathizers. All they have to do is just to call the chief judge and say, oh, I want so person to be appointed. And if such appointment is made, they just give them something like a great gift. We'll do this for you, we'll do that for you. Because of need, sometimes, some of the state chief judges may not be able to say no. So in a way, it also impacts on the issue of the quality of appointment of the judges, especially at the state level. Even though at the federal level, it has little or no, it plays little or no role.
Does the bar have, or can they have any role to play in stemming all of this?
Well, the role assigned to the bar under the current setting is not what one would expect. For example, under the current dispensation, the NBA president and some the nominees of the NBA are appointed into the NJC, which is the body that does the ultimate appointment. But at that level, so many procedures will have been passed. For example, nominations will have been done. The prospective judges will have been screened and recommended from their respective states. So the involvement of lawyers who are members of the NJC is just to ratify. And of course, once you have recommendation to say, so person is qualified, and because the procedure has not been made too transparent, it's difficult for them to make a much impact. So I think the role, the bar ought to be given more room. The recommendation of somebody who is aspiring to be a judge, the recommendation of the bar ought to be taken very seriously, so that if the bar says, oh, this person in our view is qualified and we give our reasons, he's taken as such. If you say he's not qualified for so and so reason, then they should be taken serious. This is especially so because as lawyers, we know ourselves very well. It's either we have practiced together at some point, we have appeared before some in the lower courts who are aspiring to become high court judges, or we have had very critical things about them. So I think the bar ought to be given more role right from the commencement of the process, and not at the level of the NJC, where all they do there is just to ratify appointment process that had been kick-started at the state level.
Well, one wonders what role the body of SANs might also be able to play in that regard. But for you, how significant are these issues in the administration of justice? There are those who would say, look, at the end of the day, we've had all of these cases going on, all of these particular issues you're raising going on for so long, and it's still the way it is. Who is supposed to take the lead in ensuring that some of these issues are at least considered, even if not, significantly implemented?
Well, given the prevailing circumstances and the state of the law, I think the VA is doing its best. All it could do now is to call attention and do all whatnot of the state of the law. The VA is somehow handicapped. The role the VA cannot play more than the role assigned to it by the law. That is the truth. But of course, when we talk of this appointment process, it has far-reaching implication on the dispensation of justice. One, a judge who is not competent, or a judge who is wanting in character, is a potential disaster to the system. Because if you have a judge who is not competent, if the ability to dispense justice in accordance with the laid-down procedure is impaired. Of course, because of incompetence, the process is also unnecessarily slowed down. Then when we talk of lack of integrity, it is a big problem. It means that people may not get justice from such court. Let me make this point clear that the observation about some of these heresies is in relation to only very few of the appointments made. That's the truth. Most of the appointments made so far are good, but some people have raised questions in certain instances, and as the practitioner, you also appear before some judges, and the kind of expectation you have pertaining to a judge of the Superior Court is not met. So that is the way it is. The body of senior advocates, unfortunately, have no statutory role to play in the process. It is only the MBA through its representatives on the NJC that have some limited roles to play. So by and large,
yeah, we'll go to break, but we'll return and talk a little more on the administration of justice, the body of senior advocates, and more when we return in just a moment. Join us again. Welcome back to Sunrise Daily. We're taking a look at the judiciary in the last year, even though they have their own calendar year. So how did it play out for them, those who are in the sector themselves? And then what do they think can be done to improve the sector so that, you know what they say about justice not just being done, but to be seen to have been done? That is a very important component. But Mr. Eleja, let me just get this out of the way. When you mentioned the body of senior advocates, what's the essence of that body in the first place? Because there are those who thought that, well, the body had to come together because, well, if care is not taken, the MBA is going to be, I mean, there are a lot of young lawyers who are coming up and they want a big role in the MBA. So the body of senior advocates had to be formed so that, you can have some sort of presence here and there. Could you talk about that?
Well, as the name suggests, the body of senior advocates is a body that is set up to cater for the interest of the profession. And it is also designed to ensure that as senior advocates of Nigeria who are elders in the profession, that things go the way they ought to go. Let me make it clear that the body of senior advocates of Nigeria is not in any rivalry with the NBA. The body appreciates the fact that we are an integral part of the fold of the NBA. But you know that in every profession, there is always room for people to aspire to get to the top. And the conferment of the rank of senior advocate is acknowledged as a sign of excellence, even though in every human institution you can't talk of perfection. So to that extent, it is a body of eminent lawyers who have reached the peak of the profession and who have a lot to offer in the course of ensuring that the administration of justice is better run, and even providing the support for the Nigerian Bar Association, which is the parent body. Of course, it also takes care of the interest of its members, organizing annual dinners, and a few other social functions. So that is the body.
They can do all this. All this can still be done while still being in the NBA and not forming a different body.
You know that hello? Are you with me?
Yes, we can hear you.
Yes. You see, it is not every lawyer who has been called to the bar who is a senior advocate of Nigeria. As a body, we have certain interests that are peculiar to us. For example, we have our annual dinner, which is for senior advocates of Nigeria alone. We also try to contribute money to assist certain causes. So it is not as if all our interests could be totally taken care of by the NBA. So we have interests that are peculiar to us. And even as a body, the voice of the senior advocate of Nigeria is seen as a very serious complementary voice to that of the NBA in any given situation.
Let's also hope that the body of senior advocates can do something about the strike that you said really disrupted things last year, especially the Judicial strike. Do you see that happening again in the year 2022? And how can we stave it off? Especially since the issues have not been rapturously resolved.
Well, that is a very good question. The issues that led to the problem, that led to the strike, are still with us to a very considerable extent. They have not been resolved. So to that extent, one may want to say that there is a possibility of the strike coming up again. My own counsel to Judicial is that we're all stakeholders in the administration of justice sector. And if they went on strike for 2 months and not much had been achieved now, and who are the losers, the litigants, the society, many of our colleagues who could not earn their living in the course of the strike were the main losers. The governors who are responsible for these problems did not lose much. But they didn't lose their sleep, they were going up and down. Especially so because even those who have political cases before the Supreme Court and other courts, such matters were being attended to. So my appeal is that, yes, while it may be said that the reasons are still there, Judicial should look for a way of addressing the issue this time around, so that the administration of justice is not, administration of justice in the country is not brought to a halt like it happened the last time. I will also urge them that the emphasis now ought to be concentrated on states that have not taken steps to do the needful in this respect. Because at the federal level, the federal courts, how can anybody be complaining that there is no autonomy there? All the federal courts are enjoying their autonomy, even in some states like Lagos State and probably Rivers and a few other states. You can talk of autonomy in those states. So why then do you now embark on a blanket strike to stifle administration of justice in the entire country? I don't think it's a fair enough a system. In any event, I want to urge the state governors who are yet to key in to please do the needful, because the administration of justice is something that is so important. Illegal detention of people on account of strike is something that cannot be quantified the monetary term. So that is my appeal to the state governors that are yet to key in. That is my appeal to the judiciary staff of Nigeria. They should have a rethink about the modality and even the scope of the strike if they must raising the issue again, if it has to be revisited.
All right, let's bring in Mr. Abioye on this matter, because, I mean, some of the issues that had been raised previously, even before now, was that why did Judicial have to embark on a blanket strike? Because some states were already, you know, adhering to all of those processes. So it was, to them, a fault that Judicial had to embark on a nationwide strike in all the courts in the country.
Yeah, thank you. To the best of my knowledge, no state has complied to the provision of the Constitution 100%. And when it comes to the compliance to the rule of law, you can't say...
so some of them have been, what, 98%?
How can you say, somebody says, I mean, nobody, I mean, no state.
No, you say 100%.
Yes,
so to what extent have those ones complied, if not 100?
Well, I mean, they can speak for themselves anyway, because the Learned Six said some states had complied substantially, perhaps. But to the best of our knowledge...
Do you disagree with that?
I disagree. You know.
But you said they've not complied 100%.
They've not complied 100%.
It means they've complied to some extent.
He didn't say to some extent.
No, you said 100%.
Yeah, I didn't. I said for somebody to comply to the rule of law, it has to be 100%. It has to be 100%.
So is this matter about the Executive Order 10? So it's about the rule of law.
I don't want to talk about
the reason why you went on strike.
I don't really want to talk about Order 10. It's in the court already. So I don't want to talk about Order 10. So I want to talk about the Constitution.
Is that not why you went on, part of why you went on strike?
No, not at all. I mean, we have been on this for some time. And our argument is based on the Constitution of the Federal Republic of Nigeria, Section 121, subsection 3, Section 81, subsection 3, Section 162, subsection 9. So we don't have issue with issue of Order 10. Before the Order 10 came, the Order 10, like I used to say, is more or less like you, as a teacher, going into the classroom with a cane in your hand.
No.
Do you need it?
How do you mean? Because, I mean, the governors argued about that, saying, look, they didn't want that the federal government cannot dip their hands into their own purse and pay directly to
I don't want to comment on
the
Order 10, really. So let me talk about the Constitution, because that was already in court. That don't be decided. The matter is already in court. I don't know whether you're aware. So I don't want to comment on that. So, but let me talk about the Constitution of the Federal Republic of Nigeria, which is the grand norm, and upon which the democracy is said to be established. So if you say that, okay, the 100% compliance make an executive arm of government to be functioning, so why not allow the 100% compliance to the Constitution to also allow the other arms of government to operate? How will you say that, for me, 100%, I comply with the Constitution of the Federal because it pays me. Okay. And other arm of government, I can reduce the percentage by which I can comply to the Constitution. So
help us understand this. As a union,
yes,
when unions go on strike here, we all know and we see that whatever they ask for, they don't get 100%. So in this case, you're saying that whatever you went on strike for has got to be done 100%.
This particular case is a different case entirely. This is the first time in the history of this country, I stand to be corrected, that a union will go on strike based on the provision of the Constitution. So it has also been a matter of welfareism for our union members and all and all. So our own take is that the Constitution of the Federal Republic of Nigeria, we are citizens of this country. We are not only fighting for our own welfareism. It's for the entire, members of the society. So it has to be 100%. When it comes to the compliance to the Constitution of the Federal Republic of Nigeria, you can't select parts of to comply with the other parts.
So what part of the Constitution have not been 100%? What's the balance that's not been complied with? The Learned Silk, as you called him, cited Lagos and River State as having substantially complied with some of these things that you're talking about. So what are the shortfalls that they have not done?
Well, it is subject to be proven, by whoever asserts that. The assertion was that some states, he mentioned that. So it has to be brought to fore, how they're going to substantiate that. So, but for me, in the union, at national level, the report we got, because we got the report from all the states, we have chairmen in all the states. So, and they gave us the report that no state has complied 100%.
That's why I'm asking.
Yes.
To what extent? What are the things that have not been complied with?
Okay, thank you. let me talk about the current procedure now that have been laid down for the compliance. Because they were saying, when we went on strike, part of the arguments of the governors forum was that there was no process of compliance in place, for the provision of the Constitution to be totally obeyed. Okay, we said, fine. And we have Chief Conciliator in person of the Minister for Employment, who waded in, and then we all sat together and we made MOA, Memorandum of Understanding of Action, rather, sorry. So, and from that point, there are some provisions that we jointly agreed upon, the process of compliance.
But you haven't answered the question, Comrade.
Yes.
What are the specific things that maybe a Lagos or a Rivers that the Learned Silk cited have not been complied with?
Okay, fine,
Just
thank you.
in specifics.
Well, thank you. For instance, capital projects, execution of capital projects. So part of the budgetary preparation is current expenditure, capital expenditure, recurrent expenditure, and all that in the budget provision. And then when they make budget like that for the judiciary, and of course, you release part of the money meant for the recurrent expenditure, you don't release the one for the capital expenditure. You want to execute the projects for them.
Oh, so the judiciary now wants to be executing
Exactly.
capital projects.
Obviously.
Which is what the governor said, well, no, you can't be carrying out capital projects because that is not the judiciary's function. That's what some of them argue. But Justin says no. They have to have capital projects carried out.
Exactly.
But does the National Assembly carry out capital projects?
I mean, I can't speak for National Assembly.
Anyway,
So
that is taken away. Mr. Eleja, it's an election year. It's a political year. Okay, just before we sign up, because we always take that out. We have had, you know the history of the judiciary when it comes to our politics and all of that. And in this year, preceding the year of the election, February 2023, what are your expectations of how the judiciary should comport itself? We have heard sundry injunctions and counter-injunctions and ex parte orders and counter-ex parte orders, all of that. So how do you propose or project that the judiciary should handle its business in this year in a way that it helps democracy to grow?
Well, thank you. In terms of comportment, my expectation is that honorable men and women on the bench should appreciate that many of the judges who have had disciplinary issues in this country, such problems have had to do with the issue of political matters. When you take the percentage of judges who had been sanctioned one way or the other, you discover that most of them arose from political matters. And of course, the recent sanction on 3 judges from Cross Rivers and one from one of the Northwest states also has to do with the political matter. So my expectation is that they should be very careful. They should realize the importance of the offices that they occupy so that they do not do anything to truncate the system. That is one. Then, because by the nature of the political matters, many of them are time-bound, this should be borne in mind so that they are promptly attended to. Importantly, too, I think there should be appropriate case management by the courts, and I think this should emanate from the heads of court, so that political cases do not suffocate other cases that are equally important, that are pending before the court. Judges who handle political matters should bear this in mind. And I think the heads of court who will do assignment of cases should also bear that in mind. Well, I think one issue which we really have to address is to revisit the Constitution pertaining to these pre-election matters. You discover that even in substantive election matters, that's talking about the after conduct of election petitions, certain categories of matters do not go beyond the Court of Appeal level. I'm talking of the legislative houses results, State House of Assembly, National Assembly, they terminate at the Court of Appeal level. That is talking even about the substantive election. How does one then rationalize the fact that you allow these matters by way of pre-election to get to the Supreme Court? I see that as an aberration. And I think it's a serious clog on the work of the Supreme Court and other courts. Even our colleagues too, I will have to appeal to them that we should avoid doing anything that could undermine the workings of the court, especially in the course of these political matters. After all, cases that were filed in different courts, which resulted into contrary and contradictory interim orders being granted, were filed by certain lawyers. I believe in appreciation of dependency of, or in appreciation of earlier orders and decisions of certain courts. It is not expected. It is not good for the system. And I think as lawyers, we should desist from it. And I think the NBA should also look into that direction so that appropriate report could be made to the disciplinary committee of the legal practitioners of the body of benchers for hearing lawyers to be appropriately sanctioned. This would be my few words for now.
All right, even though many will also be looking to see if there's any iota of truth where they say justice usually goes to the highest bidder, while they also hope to see that, well, cases will not spend decades in court. But I guess we'll look forward to some of these things in the year 2022. But we have to thank you, Mr. Kehinde Eleja, Senior Advocate of Nigeria, as well as yourself, Comrade Emmanuel Abioye, Deputy President of Judicial. Thank you, gentlemen, for coming on today.
Thank you, my pleasure. Thank you.